Today, I am lucky enough to be joined by Judge Joe Brown to go through some of the biggest stories in the news. Judge, thank you so much for joining me again.
My pleasure.
So I don't know if you saw this or not in the news, but President Joe Biden said he's seriously considering a preemptive pardon of Dr. Anthony Fauci and former House Representative Liz Cheney. To my knowledge, neither of these people have been convicted of a crime. From a legal standpoint, as president, can he do this? Should he do this? And doesn't this just make them look guilty?
Well, there is that onus of being pardoned for something. It says, what do you get pardoned for? But it's not unprecedented. In fact, Abraham Lincoln preemptively pardoned a number of people who hadn't even been charged. Barack Obama issued a pardon to a number of executives for British Petroleum with that Gulf oil rig blowout some years ago that caused all that damage before they even showed up in court. So it's not unprecedented. That's part of the pardoning powers that are bestowed upon the president by the Constitution itself. Essentially, he does not have to provide any justification. He's unanswerable, that he can pardon anyone of any federal offense that he chooses. Technically, it even looks like a president could pardon themselves. So nobody has put themselves in that position ever, and never have we had a situation where a president wound up pardoning a close family member. Not even Bill Clinton did that with his brother, who had a problem during his administration. So I'm not surprised with Joe Biden. He's been an unscrupulous scoundrel since day one. 1988, he was trying to run for president, but it came out that he had a little problem with plagiarism when he was in school, and then there were all of the misrepresentations. And I look at his career, and since his mid-20s, his entire source of income is supposedly a government check for some government job or office. But yet he's become a multimillionaire, which does not equate unless there's under-the-table bribery. He's been mediocre his entire career. He's jumped on the bandwagon after holding his finger up a lot of times to see which way the wind's blowing. And he's done a lot of damage to the American system, particularly when it comes to procedural matters pertaining to federal law and the trial of various and sundry criminal offenses. So, for example, he, Byrd, and Stennis and Eastland sponsored legislation that wiped out federal parole and probation except for youthful and minor offenses. So people have to serve effectively 95, 96% of their sentences, which isn't necessarily a bad thing, except it's been combined with some procedural aspects of the law that they are responsible for changing that allow a prosecutorial staff to intentionally charge people with criminal offenses, knowing that there's scant likelihood of a conviction just for the purpose of disabling them from doing something that somebody, for unspecified reasons, might be thinking is undesirable. That's how we got the start of what we call lawfare. In other words, you can't get a conviction, but you file the charges anyway. An exemplar of that is the 34 so-called felony convictions of Donald Trump. There is no conceivable way that those are going to stand on an appeal. They're so flawed. But it was a nice talking point, a nice way of tying somebody up during a campaign to achieve a political purpose, which, by the way, might wind up in some conspiracy indictments against people with appropriately appointed special counsel under the next administration. So it's this thing, lawfare, that can be attributed to Joe Biden, and that's a problem because he's a hack. And through the auspices of his son that he pardoned, we should have had a big, nasty can of worms opened up. Now, I happen to be in a position to have taken my leisure to go through the downloads of the 3 Hunter Biden laptops, and you will note that the press has completely misled the public by talking about the laptop singular. It's 3 of them. And there was a thing that Fox did that I was the judge over. It was a moot proceeding. We had a pretty representative jury, and the question was whether there is probable cause to believe that Hunter Biden and others committed violations of the Foreign Agents Registration Act laws. The mock grand jury found there was, and I would concur. And when you read the laptops, you could see it. So it's going to be something, I think, that will backfire on the current president, because by pardoning his son, what he winds up doing is removing criminal liability from Hunter Biden, which means Hunter Biden will no longer be able to evoke the Fifth Amendment, you have a right to remain silent, etc. And he can be called and compelled to give testimony as a witness. Now, if you bring in Hunter Biden, you do all sorts of things about authenticating the laptops, and from perusing the laptops at some length, or at least the downloads thereof, there is ample evidence to, say, indict Joe Biden himself for some various violations of the law, so he opens himself up to that. Now, if the Trump administration is astute, it will go through dotting all the I's and crossing the T's to get special counsel approved and appointed and on the job, which is going to result in some interesting indictments. I'm sure the far left will swear up and down it's retaliatory, but what I think is at issue here is the deterrent factor that needs to be brought into play to stop this from happening, because there are some precedents now that are going to come back and haunt this country in a couple of decades. See, when you set a precedent, and one side is a strong advocate for setting that precedent, there is a long-standing tradition or aspect of American law that basically winds up having that precedent come back and bite somebody that was pushing it. And see, what it does is it allows people to use lawfare for purposes of political oppression, which is the purpose of the Bill of Rights, to prevent that, amongst other things. And here they are loop-de-loop trying to get in the back door what they can't do in the front. So that's going to come back and bite them, because the nature of an administration in power and authority will be able to use what the other side set up as a precedent to flip the script. Now, we saw Kamala Harris trying to flip the script in an embarrassing fashion when she gave that pontification about following the law, and she presided over the function of the Senate in ratifying the Electoral College count and certifying that Mr. Trump is to be the next president of the United States, number 47. Now, the left is saying, see how she follows the law, and I'm going, she ought to be aptly ashamed of herself as somebody that has a law license, has been an attorney general for the largest state in the union, a district attorney, and supposedly a practitioner of the law, by not realizing the intense conflict. when it became obvious she was one of the parties to the proceedings. In other words, she was announcing that she had been defeated, and she announced her own name as a party of interest, as a candidate, an unsuccessful candidate. To any sensible lawyer, any person with any common sense would indicate that you should have recused yourself and say, I can't be part of this because I am already an intrinsic part of this process because I was the unsuccessful opponent of the victor. And that meant before it even came time to announce the results of the Electoral College, to remove any appearance of impropriety, she should have recused herself and said, I will step aside so the minority whip can assume the responsibility and act as the president pro tem for the Senate to take this announcement. And she didn't, which shows her total incompetence. One, to have been the district attorney from San Francisco, the attorney general for California, the vice president of the United States, which she is, and her unfitness to have been president of the United States because of this severe ethical lapse. If you took any of the courses that are required of lawyers to maintain their license status, you should know, you ought to know, you are required to know that when there is an appearance of impropriety, you should bail, which is the problem with Judge Meerschaum, by the way. He never should have kept himself on the case because, one, his wife had a vested interest in the outcome of the case, and two, his daughter certainly did, with $20-some million of funds that she was administering to see that the defendant, Donald Trump, was defeated in the up-and-coming election, which he won anyway. And any sensible judge, jurist, or even just someone who was an attorney who had never been on the bench knows that the judge is supposed to bail if anybody he is connected with in a filial condition or circumstance is remotely connected. See, these judgment lapses, these ethical lapses are extreme. And one of the problems is that we have a lack of practical ethics that have manifest in our court system, state and federal, and in our legislative and executive systems around the country, both state and on the federal level. And this is just an illustration. It's never occurred to anybody in the media, it seems, to bring this up, but I do. And it's appropriate. See, these things of exercising your First Amendment rights become matters that are not only of concern to you as a right, but as something commensurate with your duty as a citizen. See, speaking out is not without cost. I think in the last 18 months, I probably lost $2.25 million worth of income because reruns are canceled by far left stations because they don't like my political stance on things and my vehement opposition to what I look at as a source of unethical conduct, of felonious conduct, of incompetence in governance. So sometimes you have to accept the consequence, and as a man or woman who is a citizen of this great republic, you have to take a stand and say, sometimes it might cost me my life. And we've got a lot of heroes in our country's history who've paid the ultimate price to stand up for what is necessary and ensure by their own well-beings that this country continues as a republic. But that seems to be some obsolescent idea these days.
Yeah. let me get your take on this. Why do you think Judge Juan Merchan in New York is going forward with the sentencing of Donald J. Trump?
He's a damn fool.
Okay.
Plain and simple. See, here's what's going to happen. If he sentences Donald Trump and does not say in retrospect, the court is reconsidering the motion to dismiss and granting it, he's going to set this constitutional crisis up. Since it's the people of the state of New York versus Donald Trump et al., and Donald Trump is now the presumptive 47th president of the United States, his election by the Board of Electors, the College of Electors, has been certified and accepted. What winds up happening is that every single state whose electoral college contingent is gone for Donald Trump will now be thwarted in their efforts to select the chief executive officer for the United States, of which they are a component part, and that goes directly to the United States Supreme Court. So what also happens is that as commander-in-chief of the armed services, if somebody were to try and, say, take the president presumptive into custody, then you're going to put themselves against the federal government, manifest through the Secret Service into an opposition to New York authorities, and you're going to say, we're going to take him into custody, and the federal side is going to say, no, you're not. So what happens? Are you going to have a junior grade civil war, a shootout between the representatives of New York and the federal government? No. And this is not without precedent. John Wayne, back in the 60s, starred in a movie called The Horse Soldiers. It was a badly fictionalized account of then General Grierson conducting the largest cavalry raid of the Civil War through the South. Now, Grierson had a large black cavalry contingent composed of cavalrymen from Memphis and Jackson, Tennessee, that composed 1/3 of his force that was completely left out of the John Wayne movie. He wound up, as a result of that, being offered a colonel. Well, he was offered the position of being the colonel of the 10th Cavalry. He accepted it, and down in Texas, the Texas Rangers attempted to arrest Colonel Grierson. So on orders of General Sheridan, who is the commanding general of the United States Army at the time, the United States Army said, we dare you try to come in here and arrest Colonel Grierson. So that is a precedent that's already on the books about what happens when a state attempts to intervene and thwart or arrest a federal officer. And in this case, it is the exact highest you can get, Commander-in-Chief of the United States Armed Services. So here is New York getting put in a position by Judge Merchan of going out and arresting the presumptive next president of the United States of America. Ain't gonna happen. Next thing is Merchan should have recused himself because his wife and his daughter had a severe or a deep interest in the outcome of the trial. I've already spoken on that. Next thing is a judge who has been that for longer than Merchan has been. I'd say this. He was dead wrong, and he refused to, after repeated requests, give the proper instructions to the jury. And under American law, universally under American law in every state and for the United States, on the federal level, if the judge gives the wrong instruction to the jury, it makes no difference how long it has been since somebody had the opportunity to raise the issue, the conviction is invalid. And synthesizing what Merchan was facing was a charge that Trump et al. Had paid hush money to hush a crime. The problem is that the state was required to prove the existence of an underlying crime that was hushed. They never did, and in spite of many requests by the various defense attorneys, Mearsum refused to instruct the jury that they must first find that there was a crime that was being hushed and that hush money was paid to hush that crime. He refused. So the conviction is totally flawed. And it looks like when you back off, somebody decided that they were going to encumber Donald Trump's chances of being president 47 by putting these convictions so you could see just what you saw in the press, convicted of 34 felonies, knowing they would not stand. And since there are meetings between all of the parties involved, whether you're talking about Letitia James, Attorney General of New York, you're talking about Bragg, District Attorney General in New York, whether you're talking about Smith, Special Prosecutor, who it turns out was inappropriately appointed, whether you're talking about Fannie Willis in Fulton County, they all met up in the White House with Kamala Harris to discuss what. Was it we're going to thwart Trump, or was it something else? And we have the specter of Attorney Wade spilling his guts. So he would benefit from being allowed to plead guilty to an offense that had a low sentencing cap, since in the federal system, thanks to Biden, they cannot plea bargain. And if it turns out that they had an agreement to thwart Trump, then that becomes a conspiracy. And under American law, conspiracies are viewed as so dangerous that the rules of evidence are altered very significantly. So all that is necessary at that point is to show that somebody participated in reaching this agreement, and that any one person to this agreement committed any overt act in furtherance of the conspiracy, and that brings all of them in, and you don't have to prove that each and every one of them had an intent to commit the crime. It is even more serious than simply being an accessory to a criminal offense. You become a primary part of a conspiracy. So I imagine that with Wade's testimony and a properly appointed special counsel, a team of special counsel for prosecutorial purposes, we will have the specter of the current Vice President of the United States, Letitia James, Attorney General of the state of New York, Fox, state's attorney or equivalent of attorney general for Chicago, in Illinois is brought in because of that Jussie Smollett thing, where you got the fake noose, et cetera, and that was to thwart Trump. And then you have the thing with Fannie Willis down in Fulton County, Georgia, with the intent of thwarting Trump. And you have Smith going after him, and then you have Mearsum, who is insisting on going forward with the sentencing, which is going to be a real live mess. So what in the devil are you going to do with this except say this is a very bad precedent that we cannot allow to stand as a republic, and be damned the appearance of it looking like it's retaliatory. It's got to go forward. Now, I will offer something else. This Democratic past the last Congress, Democratic House, is going to severely regret something they did, because they set up a precedent. And that was to proceed against someone who was no longer holding an office in an attempt to get a successful impeachment proceeding going against them. They filed articles of impeachment against Donald Trump when he was actually occupying the White House as president. And then after he was no longer holding that office, they proceeded again to set the precedent up. Now that means that under that precedent, Joe Biden is liable for prosecution for what he did as vice president under the Obama administration. And Kamala Harris is liable for prosecution for conspiracy with what she did as vice president with her meetings with these various and sundry prosecutorial entities to conspire against Donald Trump to prevent him from being president of the United States. So that would negate that precedent, clean up the status of American law, and restore the sanctity of the Bill of Rights. And from an analysis, which I feel no reluctance to pontificate upon, the Bill of Rights was set up precisely to prevent this kind of use of government authority for political purposes to suppress dissent and opposition. And here we are in the 21st century, 235, now 236 years after the Constitution was ratified in 1789. You have an administration that has been hell-bent for 4 years to undo the Bill of Rights, which was ratified in 1791, 233, now 234 years ago, so that they could gain a political advantage. And that's just unacceptable.
Yeah. Thank you. Thank you for that analysis. I saw Tom Fitton over at Judicial Watch said he now has documents in his hand that Fani Willis, her office, colluded with the January 6th committee. So Benny Thompson, Liz Cheney, Adam Kinzinger. Do you foresee them going after Fani Willis?
Well, they're going to go after Fani Willis. Let me just say this as a preliminary observation. In my 50 years of law, I had my nominee in my head for being the worst fool and incriminating. In this case, it was himself through failure to exercise the Fifth Amendment. Fani Willis now holds the #1 position in my mind. She was district attorney for one of the largest cities in America. And one of the worst damn fool acts I've ever seen in my life. She walked in that pink, red, orange, or whatever it was dress, inside out, upside down, and backwards, hand on hip, wagging her head with that snake charm, whatever she was doing. And Judge McAfee saying, ma'am, we're trying to decide whether this can go forward. Why are you testifying? Well, I decided I was going to testify. And then getting up on the stand, and I stopped taking notes after I got to 4 pages in relatively small editions of my handwriting of criminal offenses that she had implicated herself and others in with her testimony. Start with money laundering with the cash transactions, start with a scam to engage in a conspiracy against Donald Trump and various Republican entities. Next, we come in to making a knowingly false statement to IRS, which is a federal agency, when she attested that she did not have $8,400 to pay off a tax obligation and getting time to pay, when she testifies under oath at the same time she had $15,000 in a cookie jar in cash she could have paid off on. Also, with the thing with Wade getting approved, with it turns out $720,000 in fees, and the matter hadn't even been set for trial at that point, meaning the cases against Trump et al. And her having the final say on approval with nobody over her to gainsay it. The transactions are in cash. It looks like she's getting allegedly a little under the table on that, which becomes fraud. And to put it in perspective, the President of the United States gets about $400,500 a year's salary, 400 some thousand a year. The attorney general for handling all of the legal business of the United States gets 300,500 a year, and Wade, for a state case just on preliminary matters, has gotten $750,000 already, with a likelihood of getting $6 to $8 million that he and Fannie could have split, with nobody to oversee, and she was stupid enough to let that hang out. She dumbly said, well, we didn't have an affair that we were embarrassed to talk about that fell out. She says, no, this developed after he came in, which means as a lawyer, as an officer of Judge McAfee's court, you had an obligation to inform him of that fact and offer to withdraw, which, aggravates your circumstances. The next thing, she got caught in a tail with it. The other point, she got asked about traveling to Washington, D.C., and whether she was there with Wade. She flat out denied it. But in the divorce proceedings, the wife seeking the divorce from Wade is already introduced and had admitted into evidence proof from TSA and the airline records that Wade and Fannie are sitting next to each other on aircraft flying to D.C. in the hotel accommodations. It's like, what the hell's the matter with you? You had the Fifth Amendment. Now you have perjured yourself. You have put yourself in a position of losing your law license. And then we have another problem. She refused to respond to the subpoenas from a legislative committee in Georgia that represented a committee that had appropriated considerable funds to her discretion, $7.5 million to catch up on $7 million. No, $7.5 million to catch up on prosecution of felonies, $2 million to prosecute sex crimes, and $500,000 to deal with juvenile matters. That's $10 million of Georgia tax money appropriated to her discretion, and she cannot account for its expenditure, which means under everybody's law, that committee has an opportunity to go after answers. Where is the tax money? That's $10 million that evaporated. Plus, she opens herself up to another mess, since we're talking about her. Right now, the Georgia state legislature is not in full session. And as such, it has one remedy, which is to go through a Georgia circuit court and get the subpoenas issued and served through the Georgia circuit court. They've already done that. She ignored them. She wanted to suppress the subpoenas, get them quashed, but the court ruled that since she had already defaulted on that and it was no longer active, they couldn't do anything. So that puts her in a position of being held eventually in contempt upon motion by the state legislative committee, which is in progress. And then as soon as the state legislature comes back into effect, the committee can apply to the legislative body's sergeant at arms to physically arrest Fannie Willis and bring her handcuffed and in custody before them. And then there's the third remedy. They can do a retaliation where they can cut off funding for Fulton County, all funding or part of it, or take action against Fulton County and Fannie personally to recover the funds that they appropriated that she has not answered for. The list goes on and on and on. And when you get Wade admitting that he had had meetings with other and associated entities about what to do with the Trump situation, we have a conspiracy. Now, here's the funny thing about conspiracy law. In American law, you can feloniously conspire to do a legal act in a legal fashion. If you are conspiring to achieve another action, an otherwise legally done something becomes felonious by being part of a conspiracy. So the prosecutions of Trump are not per se illegal, though foolish and pointless. But when they are part of an agreement to go after him, they become part of a felony conspiracy, which subjects everyone to a real live mess. I have tried such cases as a criminal defense lawyer 40 years ago, so on and so forth. So the law has gotten more stringent thanks to Joe Biden, and it may come back to bite him too as a result. See, there are long-term consequences when you set precedents. So I'll stop at that point because I could go on at great length about what's wrong with this picture. And by the way, I will note that the mainstream media has not mentioned anything about it, and they cite all of these so-called legal experts and legal authorities that, in my opinion, are rookies because they haven't been doing it long enough to know what's going on.
Okay. Wow. Judge Joe Brown, I want to thank you for coming on and giving us your insight. You've got just years and years of incredible information. You have such a sharp mind. I want to put a direct link to your barbecue sauce company down below. It's delicious. Is it best to go to the website, or should I push people to Amazon?
Well, let me put it this way. There are more products available through the website, which is Judge Joe Brown Barbecue, JJBBQ.com. And meanwhile, if you want to either get very angry with me or pleased with me, you might go on X, which used to be Twitter, and you can find me at Judge Joe Brown TV, at Judge Joe Brown TV.
Okay. I will put both of those, all three of those, direct links down below so people can find you easily. Thank you so much for coming on and for all that you do. I hope you have a great rest of your day.